what's the difference between a 215 evaluation and a 60410 evaluation?
Yes, a 215 evaluation really is that.
Hi, everyone. This is the Illinois Family Law Insider. My name is Katie VanDeusen from Sterling Lawyers, and I'm here with Senior Associate Cynthia Toscano. Thanks for joining me, Cynthia.
Thank you for having me, Katie.
So today we're going to be talking about understanding the differences between a 60410 evaluation as well as a 215 evaluation and how these different types of evaluations can play a role within a family law case. And so in terms of these evaluations, what exactly is a 60410 evaluation, Cynthia? And when does the court typically order one?
Yes, a 60410 evaluation, the number actually refers to the statute, so that's why we call it that. But in typical terms, it really refers to a custody evaluation. That's what it probably would be referred to by a normal person or in other states. And it's really meant to have additional information provided to the court as to what the placement and decision making responsibilities should look like for the children. So a custody evaluation really is more of a holistic, comprehensive investigation and report to the court that includes talking to the parents, talking to the children if they're old enough. They'll talk to what we refer to as collaterals, like grandparents, teachers, therapists, social workers, in order to get a very overarching, holistic view of what is going on in these day-to-day lives. And based on that, what should the court order in terms of the placement and the decision maker responsibilities that would be in the best interest of the children.
So just to clarify too, a 60410 evaluation really doesn't look into financial issues. It's really focused solely on child-related matters and child-related issues, right?
That is correct, yes.
And then what exactly, I know that when it comes to a 60410 evaluation, you already touched kind of on what an evaluator can do, right? Talking to the parties, interviewing, collaterals, but talk to me a little bit about the psychological aspect of this, because I think that's key to understanding the differences between a 60410 evaluation versus maybe a 215 evaluation, or even the role of a guardian ad litem.
Absolutely. So a 60410 might touch on some particular psychological issues, like it appears that the children might have, issues with one parent, or it appears that one parent might be dealing with some anxiety or things like that. So it might touch on specific things, but it does not do a deep dive into the mental health of the parties or the children. It is not a deep dive at all whatsoever. It's really meant to give an overarching view of the kids' lives as opposed to a sort of breakdown of the mental health of the children and the parties. So while there might be some things in a 60410 that sort of touch on the mental health, it will be by no means any sort of detailed report or evaluation in that regard.
So the 60410 evaluation, there is a psychological element to it where the 60410 evaluator really has that psychological background, performs certain testing. Typically, how long are those reports that you've seen in your practice?
They can be anywhere from 5 to 6 pages, depending if there's not a lot of issues, to 15 to 20 pages, depending on how many issues that the evaluator has to touch on. They are meant to be incredibly detailed. They are meant to go into the nitty gritty of all the issues that the parties are facing so that the judge really has all the facts in front of him or her to be able to make some of these rulings and recommendations.
And have you, in your experience as an attorney, have you ever had a 60410 evaluation kind of dramatically change the outcome of a case where, let's say, you had a guardian ad litem making one recommendation and then the court ends up ordering a 60410 evaluation and those are drastically different? And what effect have you seen that have on cases?
I don't think it's fairly common. It doesn't happen very often. A lot of times, a guardian ad litem will usually get a good grasp of a case. And while a 60410 might provide some additional details or maybe some additional nuances, they tend to be, statistically speaking, fairly in line with what a guardian ad litem recommends. However, There are, of course, always exceptions to the rule. So I actually have had a case in the past where there were two fairly small younger children, and the guardian ad litem really was recommending sort of an equal parenting schedule between the parties.
Yep.
And it seemed like both parties really had a strong relationship with the child.
Mhm.
However, there were some ongoing issues between mom and the children because the children would sometimes make comments about mom and their level of comfortability in her care that made the guardian ad litem sort of think that if there were to be a primary placement of a parent, it would be dad. Mom was very adamant that this was dad's doing, but there was no evidence that could be found to sort of corroborate her argument.
Yep.
So we did move forward with the 60410. And unfortunately for dad, the 60410 really corroborated what mom was saying because dad was not outwardly alienating the children like most people picture, where he was like very explicitly telling the children, your mom is a bad mom, you shouldn't want to love your mom, or things like that when parties typically picture alienation. It was
Right.
very sort of subtle. Like, oh, what did you do with your mom today? Oh, I wonder why she took you to do that when you know she knows that your favorite thing to do is this. Or I wonder why she fed you guys pizza. Like, I always make you guys a healthy meal at my home. Like, not outwardly disparaging mom, but really subtly doing it so that it was really sort of getting into the kids' heads and they didn't even realize what was going on.
Wow.
So the 60410 really helped bring that to light. It ended up sort of switching the guardian ad litem's recommendations to sort of give mom primary because she was really, that ended up with her making her really worried that dad would be unable to sort of foster that relationship between, the other parent and the children. So while that again is not something that typically happens, it definitely can sort of alter the outcome of a case.
How interesting, and what, your points to how subtle that could be, Cynthia, and the impact that the 60410 had in that particular situation. Wow. And I do feel like as attorneys, we have to advise our clients, specifically when it comes to 60410 evaluations, that the cost is very high and that there typically is a long delay in receiving these types of reports. So a lot of times, I feel like you have to have that cost benefit analysis with the client ahead of time. And there really is a risk associated with spending a lot of money. I've seen 60410 evaluations come back at a more cost effective rate, like maybe $5,000, but there are some that have cost 20, 25, $30,000 for these people or these parties. And sometimes you have to talk to the client about, listen, this is a little bit of a crapshoot. If we already have a guardian ad litem making a recommendation, seeking a 60410 evaluation could be it is costly. It'll delay the case and add time to the case, and you're not really sure of the guaranteed result or impact from that. But in a case like what you just described, wow, would that be worth it? Right? Like that strategically would absolutely be worth it. So it's very interesting how, from a strategy perspective, we really need to be talking through this with clients and kind of helping guide them as to whether or not it's worth it in a particular situation, right?
Absolutely. And I'm glad you touched on that because when you say delays, I think a lot of parties think a couple weeks, maybe a month or two. Like, no, 60410 evaluations regularly take like 4 to 8 months. I've seen them take upwards of 6 months because these evaluators really have to make several appointments with each party. And then it takes a while for them to be able to write the report. So when we say delay, we mean significant delays, like months of delays. And especially now with the new Illinois Supreme Court guidelines, where the Illinois Supreme Court really wants parenting plans to be entered within 18 months. By the time you're discussing a 60410 evaluation, at that point, typically you've already gone through mediation, you've already gone through a guardian ad litem. This is sort of your last resort. So you've already been litigating the case for quite some time at this point. And a lot of times you might not have the additional time in order to meet the 18-month, regulation put in by the Illinois Supreme Court. And judges really are hesitant to go past the 18 mark if they really feel like they don't have to. So that is definitely another thing, strategically speaking, that we have to consider when evaluating this on a case by case basis with our clients.
I could not agree more. And then the other piece of things too is to always remind clients this is all within the court's discretion. just because we ask for one doesn't mean that we're going to automatically get it. And I think strategically, we also as attorneys have to really talk to parties about how we have to have a valid reason. This is not an expert that just gets doled out on every single case file. And we really need to have a basis for why there may be a psychological aspect to a case, or where maybe parties or children have these types of issues that need to be further investigated versus like maybe a normative case which only has a guardian ad litem. So it's very, very, I think, fascinating talking about 60410s. And I think just thank you, Cynthia, for like sharing that experience with that particular case you had. And, shifting gears to 215 evaluations, what's the difference between a 215 evaluation and a 60410 evaluation?
Yes, a 215 evaluation really is that deep dive into the mental health of the parties that the 60410 doesn't get into. So a 215 really is more focused solely on the mental health of the parties, sometimes the children as well, if we believe there might be mental health concerns with the children, but it really is focusing on giving like potential diagnoses maybe of mental health issues, potential ways that these diagnoses might affect or impact not only the relationship with the children, but the relationship with the co-parent, and then how that might potentially affect their ability to either parent in the future or foster a relationship with the other parent in the future. So the 215 evaluation really is what parties more typically think of like the mental health evaluations that really say, well, I think my ex-spouse has X, Y, and Z. I really think they're bipolar or whatever it is that, might come to mind. If there is a reasonable basis for believing that that could potentially be true, that's when you start discussing potential 215 evaluations.
So is it fair to say that maybe a 215 evaluation is almost focused on a factor within the statute as it relates to parties and their mental and physical health versus a 60410 looking at all of those factors and making a recommendation as it relates to those child related issues?
Absolutely. That is a very concise way of putting it. That is exactly what the difference really is between the two.
And then have you ever seen a case where maybe the other side or even you have filed a request for a 215 evaluation and the other side has argued against it or objected to it? How does that look, or what impact could that have on the case?
To be honest with you, whenever anyone objects, if it's not a financial objection, because that's always reasonable. If the parties can't afford it, they can't afford it. But if it's any other objection besides financial in nature, it sort of tends to give the court a bit of like a raised eyebrow, because it's one of those things where if you got nothing to hide, then what really is and you have the funds for it, then what is the issue with moving forward? So typically, again, and just because someone requests it doesn't mean it's going to get granted. Like judges don't just go out doling 215 evaluations. But if someone files a motion that provides a reasonable basis for why a 215 evaluation could really be helpful in this case, and the other party is objecting for no reason other than the finances, it really does sort of give the court a raised eyebrow in terms of like, what does this person not want to come to light?
Agreed. And I feel like a lot of times, whenever this has come up in prior cases for me, strategically, if there is a question as it relates to one party's either mental or physical health or their ability to parent as one of those factors, I usually will make or suggest that the 215 evaluation be mutual. Have you ever done that before in the past? Yeah.
Absolutely.
Yeah. I think that way it kind of, just to your point earlier, like if we have nothing to hide, absolutely, let's do this. So, and then typically, what's the cost differential between a 215 evaluation and a 60410? I know we've gone over the cost of a 60410, but based on your experience, what is the typical cost of a 215 evaluation?
In my experience, they are still very costly, but because they are a more sort of, focused report as opposed to a very holistic thing and a lot of different issues that need to get investigated, while it still costs several thousands of dollars, it's still normally much more reasonable financially as opposed to a 60410.
I totally agree. So, wrapping up the difference between a 60410 and a 215 evaluation, what should parents do to prepare themselves if they know one of these evaluations is coming?
It's hard to prepare in the moment because it is sort of a holistic view. So they are not just going to look at what's been happening in the time leading up to the evaluation. They are really going to be looking at more long term, the 18th, potentially 24 months leading up to the evaluation. So if there is some sort of sudden switch, that's obviously going to play a role in the evaluator. However, if you are the parent that has been doing everything right, that is the primary parent that, has been doing everything you can in your child's best interest, then you just really need to continue to do that and bring that to light in the evaluation and really bring that to the attention of the evaluators. Like, this is what I've been doing, not only right now as part of this case, but, throughout the time, to make sure that my children's best interest and their concerns and mental health are primary focus of what I'm really fighting for here.
And then flip side, what would your advice be for a non-custodial parent or maybe the non-primary parent? Would it be the same?
It would be similar in the regard that you still want to bring to the attention everything you've been doing to sort of be as involved as you can in the life of your child, but then there also is sort of an additional layer to it, and that you also want to bring to the attention what has prevented you from being involved in the life of your child. Is it the miscommunication with the other parent? Is it other life factors that are no longer applicable in your life? Things of that nature that you want to bring to light as to why now is the time that you want to be more involved.
And I think bottom line, Cynthia, talk to your attorney, right? That's exactly why your attorney is involved, to help guide you and prepare you accordingly. And I know, one of these evaluations can be daunting or overwhelming, but an attorney can really help walk you through what you need to do and what you can anticipate and expect. So thanks so much, Cynthia, for joining us today, talking about the difference between 60410 evaluations and 215 evaluations. Thanks so much.
You're very welcome.
Custody evaluations like 604.10 and 215 can have a major impact on parenting time. There's something many parents don't expect. Even after an evaluation, one wrong move can still put custody at risk. Thinking about relocating? Watch this next video to learn how to move without jeopardizing your parenting rights in Illinois.